appearance.
All right. Well, thank you very much for that report, Chanley. Joining me now is criminal attorney and former prosecutor Florina Altschuler. Florina, thank you very much for joining me this evening. Great to see you. And let me ask you a little bit about this case. It took a long time. I mean, there's been years, and we all been saying that this case would eventually result in murder charges. Love to get your reaction to today's announcement.
This is a complicated situation with a multi-year investigation. I think the autopsy results still remain to be addressed. I'm very curious to see what those autopsy results of his wife will show. It appears that there's motive. It's very suspicious that Chad remarried just 2 weeks after the wife's passing. That certainly suggests an ongoing relationship that pre-existed her supposed natural cause passing in her sleep. It just does not sound right. There's a lot of evidence out there about this cult-like following that they had, the podcasts that were produced. I suspect that there's going to be volumes and volumes of audio recordings from those podcasts and from statements that they've made where I am suspecting they co-conspired together to get rid of his wife and then as well the children.
Now, with these charges coming down, there's something on the table. We're not sure which way prosecutors are going yet. I want to play a quick soundbite from today that they haven't made a decision on the death penalty. Let's listen.
The penalty for the most serious charges range from life in prison without the possibility of parole to the death penalty. We will not be disclosing further information about what penalties we will pursue for these charges. By law, however, we must make a decision and inform the defendants on whether we will pursue the death penalty within 60 days after the defendant's first entry of a plea. We know you have a lot of questions, but at this time we will not be taking questions while the matter is pending. Rob and I have a legal and ethical obligation to protect the defendant's rights to a fair trial. We take this obligation seriously, and we will continue to balance the public's interest in this matter with our legal, ethical obligations, including our responsibility to protect the integrity of the facts and evidence and minimizing unnecessary and erroneous publicity. This investigation is far from over, so if anyone has information related to these crimes, please contact Fremont County Sheriff's Department at 208-624-4482. The indictments have more details that should provide many answers to your questions. Under the law, Lori and Chad Daybell are presumed innocent while charges are pending.
Florina, I'd love to get your thoughts on why they haven't made a decision yet on the death penalty. And I think it could have a real effect on the outcome of this case in terms of getting one side to turn against the other.
Well, and sometimes they offer taking the death penalty off the table as a plea bargaining tool. So if one of the partners decides to either roll on the other or just take the guilty plea in exchange for a life sentence, the prosecution will agree to remove the death penalty. Given the complexity of this case, given the number of deaths, given that these are children, given that there's this other murder of the former spouse, supposedly, this is a case that's appropriate for the death penalty, but this would also be one where they may use the death penalty as a bargaining chip with defense counsel to see whether that's something that would entice one of the two to take a plea.
So you think it's a smart way to go about it is not put it on the table, just negotiate with it, rather than putting it on the table and perhaps taking it away if someone is willing to give information against the other.
That's exactly correct, Michael.
Now, as a former prosecutor, how does that work? You would think that you use it more as a shield or a hammer.
Well, look, you could use it as a sword or a shield, either way, right? There's certainly incentive by the defense to not face the death penalty. And so if, depending on how much evidence there is against the defendants, if the defense believes that the case is strong against them, they would be incentivized to take a plea in exchange for just a life sentence versus the death penalty. There's also an incentive to enhance the prosecution's case by enticing one of the two to cooperate to strengthen the evidence against the other.
All right, now we're going to take a look at that paperwork, find out as much information as we can. Of course, we'll continue to keep you all updated on that. Florina, please stand by. We have to take a break right now. And a lot happened in court today in the killing of Mollie Tibbets murder trial. Tibbets is the Iowa college student whose body was found in an Iowa cornfield in the summer of 2018. We'll see how lawyers for the man charged in the first-degree murder in her death began building their defense's case for their client right after this break. So keep it right where it is here on Court TV. Hello and welcome back to Court TV Live. I'm Michael Ayala. In the killing of Mollie Betts murder trial, the defense began its case in chief today. Christian Bahena Rivera is charged with first-degree murder in the death of Mollie Tibbets. And today his attorneys finally delivered their opening statements and called witnesses, attempting to depict Bahena Rivera as a hardworking man with no violent history at all, and whose main focus was on supporting both his family in Mexico and his young daughter here in the United States. Now, of course, prosecutors say Bahena Rivera is the one who led them to the body of Mollie Tibbets and committed her brutal murder. The Iowa college student went missing after going for a run in July of 2018. After an extensive search, evidence led prosecutors to Bahena Rivera, and police say he confessed to killing her. Now, let's get to the heart of today's court action in our debrief. Now, Court TV legal correspondent Chanley Painter is live in Davenport, Iowa. All right, Chanley, let's start with the defense's opening statements. They deferred it until after the state's case, and so finally the jury heard from them. How did it go?
Yeah, the anticipation building, finally hearing from the defense version of what they say happened, and that arguing really that the defendant deserves justice in this case. Also, interesting strategy, but really attacking the DNA evidence of the prosecution, the alleged confession brought before this jury from the prosecution, and really painting Bahena Rivera as this nonviolent family man who came illegally to the United States from Mexico when he was a teenager, but wanted to give his family a better life. Let's listen to part of the opening right now.
The state in this case, they got what they wanted, and they closed the case. They got what they needed. There was an intense amount of pressure, that's what the evidence has shown you, to close this case, to arrest someone for this vicious crime. And instead of continuing to work the case, instead of continuing to work the evidence, they just submitted it to you.
In the defense opening, Michael, she goes on to tell the jury that the 11-hour interview or interrogation, that the authorities were putting words in her client's mouth, that they're the ones that first said that he perhaps blacked out and didn't remember part of the murder of Mollie Tibbets. So some interesting things there.
All right, now, Chanley, the defense started their case, and they called to the stand a DNA expert who testified that there were other DNA found in Bahena Rivera's trunk, and it didn't belong to him or Tibbets, and that the state should have investigated it more. Tell us about that.
Yes, this definitely goes along with the theme of the incomplete investigation by police, something we've seen on the cross-examination of the state's witnesses, and now bringing forth their own experts, not only this DNA expert, but also a fingerprint analysis expert to point to other fingerprints and DNA in that trunk. Let's listen to part of Dr. Spence.
Well, in the instance of, for example, 58.1, there were 17 unaccounted for alleles. When I just to refer to what I mean by unaccounted for, we have to recall that the only two individuals we're comparing this to are the only two individuals that were typed in this case, the only two references, and those were Ms. Tibbets and the defendant. Outside of their inventory of genetic markers, what we call alleles, were 17 unaccounted for alleles that had to be from somebody else or more than one other person, and there was a clear indication there was female DNA within there that, once again, we don't want to confuse that that might have been Miss Tibbets. We're talking about a female other than Miss Tibbets.
So there, again, the defense making the point with both Dr. Spence and the fingerprint expert that there's other fingerprint DNA, possibly other access to this trunk or the car that Bahena Rivera was driving. On cross of both witnesses, though, Michael, the prosecution pointing out that Mollie Tibbets places her in the trunk. Did you test her fingerprints? Well, they couldn't test her fingerprints based on decomposition. And it just makes sense with other items that you can't tell when someone's DNA was placed where or how. So anyway, some points scored for the prosecution even on cross-examination of these witnesses. Yeah,
and again, the extra DNA shows that perhaps some other people may have had access to the car, which the defense, of course, would want to highlight. Now, Chanley, in an attempt to give the defendant a little more depth, the defense called a couple of family members of the defendant. What was their testimony like?
Yeah, the aunt of the defendant, as well as the mother of his minor child, really helping the defense paint a picture of who they believe Bahena Rivera is as a person, his history, some of his background. And Michael, I have to say that his demeanor, the defendant's, starkly changed inside the courtroom, especially when his aunt took the stand. Usually he's watching testimony back and forth, but his head went down and he stared at his feet or the floor, it looked like, most of the time. And that was, of course, the print reporter said maybe he was fidgeting with his fingers. So that said a lot probably to this jury as well. But also the mother of his minor child was someone who knew him and talked about who he was as a father and how he paid child support. But also she talked about how she went to school, high school there in Brooklyn, Iowa, with some of the other people we've been hearing from, including Dalton Jack. Let's listen.
I want to ask you about a man named Ulysses Felix. Who is that?
That's my cousin.
And did he also go to Brooklyn High School?
Yes.
What year was he in relation to you?
I believe he was 2 years younger.
Did Ulysses Felix know Christian Bahena Rivera?
Yes.
Has Ulysses Felix spent time at Christian Rivera Bahena's house?
Yes.
Did Ulysses Felix know Dalton Jack?
Yes.
Objection, speculation. Overruled, the witness may answer if she knows.
Yes.
Did you know Dalton Jack?
Yes.
Do you have an opinion as to Dalton Jack's demeanor?
From what I recall, I remember he was pretty racist.
No further questions.
And interesting, Michael, Ulysses Felix, that is mentioned there, the mother of Mollie Tibbets actually took him in to her home when his family, his parents were deported, and let him stay there after the death of her daughter, Mollie Tibbets. It's actually an exceptional story.
Now, a big moment this afternoon was when Dalton Jack, the man we were talking about, former boyfriend of Mollie Tibbets, was called as a defense witness. Now, when he was on the stand, he denied being a racist, and he was also peppered with questions about whether he was somehow involved in Mollie's death. So tell us about his important testimony.
He certainly was. He was in the hot seat again today with the defense attorneys really grilling him about his relationship with Mollie Tibbets and the other women that he may have cheated on her with over and over again, trying to pinpoint a timeline. It was one point where the defense attorney asked him if he had some memory issues because he couldn't remember a lot of details apparently on the stand. But let's take a listen to some of his testimony today before the court.
Now, it's your testimony, Mr. Jack, that you had nothing to do with Mollie Tibbets' abduction. Is that what I am to understand?
Yes,
You had nothing to do with Mollie Tibbets' death, right?
correct.
You loved her too much, is that right?
That, and I wouldn't harm her or any innocent person, but yes.
Of course, the details got pretty intimate for Dalton Jack about Jordan Lamb, someone that we expect the defense to call. This is the girl that he cheated on with a couple of times, sounded like today, based on his testimony. And of course, the other friends that Mollie knew, that talked to Mollie, that confirmed to her that Dalton wasn't faithful to her, and how upset Mollie may have been, and how she even quit wearing her promise ring with Dalton at one point. So interesting to recall Dalton Jack to really, I guess, go to the theme here that we keep seeing: incomplete police investigation, but also all these other suspects that were viable that the police should have looked into a little bit more.
Now, Chanley, you mentioned a little bit there, but what can we expect tomorrow when testimony resumes?
Well, we expect the defense to call a few more witnesses, including possibly Jordan Lamb. She's been subpoenaed by the defense. Also, Jackson Eichman. He was one of those other suspects named on cross-examination multiple times by the defense over the last few days. He's subpoenaed by the defense to possibly testify. So we'll just have to see. Maybe a couple of friends of Mollie Tibbets also. Hope Beck, a familiar name. We've heard these names throughout the testimony on cross. The defense keeps bringing them up. If they do rest their case, it's possible, Michael, that the prosecution would want to put on a rebuttal case based on the defense and what they brought forth. If not, we will likely have closings probably Thursday in this case.
All right, Chanley Painter, thank you so much for that report. Truly appreciate it. Let me bring in my guest now. Still with me is criminal attorney and former prosecutor Florina Altschuler. And Florina, first and foremost, I want to ask about the defense's tactic here of waiting until after the state's case in order to deliver their opening statements. As I was listening to the opening statement, I thought, I wonder if it would have been better early on to help signpost some of the cross-examinations that they were doing. I thought they scored some points on cross-examinations, but it may have gotten lost because the jury wasn't quite sure where they were going.
Yeah, you have an excellent point there. The rule of primacy and recency is really supreme in trial technique. So the first thing that the jury hears and the last thing that the jury hears is what's going to stick. And when the defense chooses to exercise their right to go ahead and wait until the prosecution rests to first speak to the jury through their opening statement at that point, what they've strategically done is, on the one hand, marshaled the evidence and waited for that evidence to then spin it into their favor and to develop what strategy they're really going to use as their defense once they know what the full extent of the prosecution's evidence is. But conversely, to their detriment, they haven't been able to marshal that evidence or put a spin on it right up front. And so the prosecution got that stage for the first 4 days of this trial without really knowing what the defense's spin on it is, what their theme is, what their theory of the case is. As a defense attorney, when I try cases, I do not give up that opportunity to get my say up front right after the prosecution opens, even if I don't develop a crystal clear theme right then and there, which I like to do. At the bare minimum, I can at least impress upon the jury the importance of the burden of proof, and that it's the prosecution's burden to prove everything beyond a reasonable doubt. And I think the defense in this case missed that opportunity by electing to go ahead and wait until 4 days later when the prosecution rested.
Yeah, I might have to agree with you there, but I'd love to get your thoughts on how their defense is going so far. I think it was important. In so many of these cases, we don't see a real case put forth by the defense, but the defense here is really trying to put forth a case. My only issue is, I'm still not exactly sure what that case is. I'm wondering if you have a better sense of exactly what their case is. It's clear that they think the police didn't do a good enough job. That came across clearly during the state's case and their cross-examination. But now we see Dalton Jack on the stand. They're going to call some others to the stand. Are they pointing the finger at Dalton Jack? Are they saying it could be all of these people? That's why you shouldn't find him guilty. Wondering if you have a sense of the theory that they're going with.
So I think the defense is actually doing a much better job than I expected. So, what they're doing is they're raising reasonable doubt. It is not their job to prove who did it. It's the prosecution's job to do that, and to do that beyond a reasonable doubt. The defense's job is to now raise some doubts that are reasonable, that they can in closing argue the prosecution failed to prove their case. And what the defense has done rather effectively, I think, is they said, hey, look, there are other suspects here. There's more than one other suspect here. And the prosecution, or law enforcement specifically, failed to thoroughly investigate those other suspects because they suffered from confirmation bias and a preconceived notion that it's this defendant who did this. And so law enforcement marshaled all of the evidence against this defendant. Now, the hurdle that the defense here has is that none of these other suspects, one, confessed to the crime, two, led investigators to the body of Miss Tibbets, and three, had her blood in the vehicle. Those three facts are the strongest facts for the prosecution and the most difficult for the defense to overcome. So what the defense is doing to overcome those facts, and artfully so, might I add, is they're arguing to the jury that this is a false confession. Now, a person with common sense will say, okay, maybe he was manipulated into a false confession, but how then does he lead investigators to the body? And this is where I think the defense can make a stronger point, because we heard through cell phone evidence that investigators actually tracked Mollie Tibbets' whereabouts the night that she went missing to that last known location where her phone was in those cornfields.
All right, Florina, I want to thank you very much. Sorry I had to cut you off, but we do have to get to a break. I truly appreciate you being with us.